Hello, everyone, and welcome to the first episode of DBPACast, the new podcast by De Blasi Parenti and Associados, one of the main intellectual property firms in Latin America, being a reference for more 35 years. The main goal of the DBPACast is to simplify complexities with valuable, fast, and easy audio content, gathering opinion leaders from all continents in discussions about what is trending in the world in a way that it can be consumed however, whatever, and whenever you want. My name is Felipe Oquendo. I'm a lawyer and a senior associate with De Blasi Parenti. I've been working in the firm for almost 16 years now. I'm based in Rio de Janeiro, Brazil, and my focus is dispute resolution in IP and franchise in general. Uh, Today, April 26th, we are celebrating the World Intellectual Property Day, a very significant date for the IP colleagues and peers. And there would be no better day to launch our podcast, to be aligned with what has been defined and fostered by the World Intellectual Property Organization, WIPO, for this year's celebration. We have the honor to have Filip Kylvåg, senior associate at MarLaw, for a quick discussion on how IP can act as inductor of the United Nations Sustainable Development Goals. Welcome, Filip. Thank you very much for accepting our invitation. I would like you to please introduce yourself to our audience.
Yes. Hi, everyone, and thank you very much for the invitation, of course. As you mentioned, my name is Filip. The last name is a bit hard to pronounce. Perhaps it's Kylvåg in Sweden. I'm a senior associate at a boutique law firm in Sweden. We're based in Stockholm. And the main focus of our firm is IP law, of course, but also unfair competition and marketing law. My main focus at the firm is IP. I work with infringement matters, of course, but also various commercial agreements, licensing agreements, and other types of arrangements. So that's a brief background regarding myself.
Thank you, Filip. So for those who are not familiar with the sustainability goals, sustainable development goals from the UN, those are 17 very broad goals that range from social goals such as eradication of poverty, of hunger, the enhancement of a medical treatment and health in general, not only the enhancement, but the to make it available to everyone. Gender equality, social equality as well, better conditions at work, and on the other hand, goals related to the environment, such as clean waters, protection of life in land and in the sea, among other different goals. One of them is very interesting. It's innovation. So the UN, at a UN level, there are already there's already preoccupation with and a valorization of innovation and IP, and WIPO actually, which is the IP branch of the UN. WIPO actually has set up a very nice website where they explain briefly, but giving examples, how IP and innovation can help with each of those goals. And today our idea is to discuss how that is being done or can be done in our own jurisdictions. Filip, you're from Sweden, and I understand that you have some you act as well in a EU level. So can you please share with us today what initiatives and what other actions are being taken in this sense?
Yeah, for sure. And I can just start by briefly explaining the relationship between Sweden and the EU, perhaps. So if some of you aren't familiar with the structure, Sweden is part of the EU, of course, and a lot of legislative acts and yeah, directives and regulations are harmonized on a EU level. So if you're a member of any EU member state, you have a level playing field, so to speak. We have pretty much the same provisions to apply and to adhere to. And we also have a structure when it comes to intellectual property, that we have national rights in each separate country. So I can apply for a patent or a trademark, for example, to the Swedish Intellectual Property Office. But I can also apply directly to the European authority called the European Union Intellectual Property, or EU WIPO. So I can apply directly to the EU WIPO as well, to have protection in all member states, basically. So the legislature on the EU level works with directives and regulation that later on will apply also in Sweden. So that's basically how the system works. So when we apply intellectual property law, we need to adhere to both the national regulations, of course, but also the European regulation. And that is why it's interesting to also look at the European Union and the work by the Commission when you address this issue that we speak about today. So, well, if we start on a national level, perhaps, before this discussion, I actually read the Swedish Intellectual Property Office, their sustainability report, which briefly describes how the Swedish Patent and Registration Office can contribute to the UN goals. And it is apparent that they have a more educational approach to the matter, of course. If I should read just one sentence from the report, it says that we help others make the transition to a more sustainable business. So they work pretty much on an educational basis to enlighten the primarily Swedish companies, how they can protect their intellectual property rights, their innovations, and to secure a return of investments. And by doing so, they are trying to stimulate innovation and in that way contribute to a more sustainable society.
Yes, yeah, and thank you for that first explanation on the relationship between Sweden and the EU. What is interesting, and maybe not everyone in our audience knows, is that since a very, very long time, IP, there's a push for having IP law harmonized internationally, even way before the European Union and the common market even. It all began with the Paris Convention in late 19th century, and Brazil was one of the first countries to sign it. We were an empire at the time.
Yeah.
And yeah, but since then, Brazil and many other countries, including Sweden and all the EU countries, they attempt to have a level field of IP rights, and also to grant what they call the national treatment. So a Swedish company, for example, would have to be treated as well as a Brazilian national, and vice versa regarding IP rights. So it's quite easy for us to talk about IP with our foreign colleagues and friends who are in the same field, because there are, of course, some minor differences, local differences, but in general we're speaking the same language, and that is thanks to that first treaty, and then the TRIPS agreement and other treaties that have always set their eyes on the future of international trade, which is ultimately the main driving factor behind that internationalization. So it's interesting you mentioned about the educative aspect. Here in Brazil, we have as well that aspect from the BPTO. I will be using the English acronym. It's for Brazilian Patent and Trademark Office. But the actual name is something like National Institute of Intellectual Property, and the acronym in Portuguese is INPI. And it is the federal entity that is responsible for registering patents, trademarks, industrial designs, as well as softwares. Softwares specifically are in Brazil are registered by the BPTO, and the BPTO has that educational branch, especially focused on small companies and small businesses. There's of course, a presumption that medium-sized and big companies, big-sized companies are very aware of their IP rights, but not that is maybe not the case for individual entrepreneurs and small companies. Our firm has also taken part on that support for small businesses and individual entrepreneurs through a federal program that subsidized fees, the BPTO fees, and professional fees, part of the professional fees. There were other law firms as well, and for a long time we had we gave counsel and actually filed different IP for those companies. And on the specifically on the innovation side, I know that the BPTO has a partnership with the federal government for that's a virtual space called RedeSim, which is a part of a program called Inova Simples, which would in English roughly translate to Innovate Simple. And they identify small businesses that are driven by innovation. So your typical startup, for example, and there are a lot of benefits and support from the states, but specifically from the BPTO, there's a different treatment, and there's an active support from the BPTO, and not only the prosecution side of the work of the BPTO. So, and that connects with many of the points that were highlighted by the WIPO concerning how innovation can foster a better work environment and help ending poverty. It's
Yeah.
not very, it's not that strange. So Brazil is a country in development. So there are, unfortunately, a lot of areas that are quite poor at the economic margin, and it is not, it is not unusual for some of those startups or small companies or even individual entrepreneurs coming from those areas and protecting their patents, their innovation through patents or software, for example, goes a long way in protecting them against
Yeah. Yeah.
copycats, against malicious competitors, as well as giving a value. Under Brazilian law, IP is considered as mobile property.
Yeah.
So once you have that patent granted or that trademark registered, the software that is a good that can be evaluated independently of your company. So that as well helps to attract investors and to help build the company's wealth in general. So
Yeah.
that's one brand. So it's nice to have the point of view of far richer countries such as Sweden, and to see that it is also needed there's also a need to educate the companies.
Yeah,
There-
for sure. And I must say that I believe also that the Swedish IPO, they take big responsibilities. They have programs also because of Sweden's situation and Sweden being a quite a rich country. They are taking a quite big responsibility in educating also intellectual property offices abroad in Africa, for example. So they have a project with the a federal organization here in Sweden called SIDA, also together with the WIPO, where they travel to other countries to educate both companies, but also the authorities to help them build up a sustainable system. And that, in a sense, it creates jobs, of course, on behalf of the authorities, but it also helps to develop this harmonized system that you spoke about earlier, because I think that a harmonized system is very important also if IP, or in order to let IP take a bigger role in the transition towards a more sustainable society. I believe that the harmonization is very important to have, because many companies, they are multinational, they have branches in other countries, and if the playing field is not level, or if the rules vary too much, it's quite hard to run an international company, and in that sense it creates lesser jobs and etc. So I believe that this sort of cross-border education and all the systems, also with funds, for example, I know that the EU YPO, for example, also has a separate fund which is marked for small and medium-sized companies, but it's primarily to allow them to get their money back, or the receive a refund basically for application fees and stuff like that. I believe that you can be granted up to 75% of the application fees through this special fund. So I believe that those types of initiatives are very important for the subject that we are discussing today, for sure.
Yeah, that's very interesting. Regarding the fees, I should also mention that for the longest time, at least since I've been starting to work with IP, that was in 2008, The WPTO has a special fee with a very significant discount fee for small businesses and individual entrepreneurs. So yeah, there's also that kind of initiative of support. And you were talking about Africa. One of the very interesting examples that WIPO has mentioned is the effort to make African countries independent regarding vaccines. That was the example, but in regarding medical care in general, which
Yeah,
I think is fantastic. Since I was a little kid, we grew accustomed to see the aid to African countries always coming from abroad in the form of food and clothes and medical care, but always from abroad. And it's very nice to see that there are initiatives
yeah,
to nationalize and capacitate those countries to become independent and enhance the lives of their citizens.
yeah, yeah. I was thinking about that yesterday as well. Speaking about vaccines, for example, do you see any difficulties, or do you see that there is a collision between IP rights, in a sense that it creates a monopoly to important innovations, for example, vaccines? Do you see a potential collision there between the goals and IP rights? I mean, perhaps a risk for vaccines becoming something that is only available to the richer countries due to patents and stuff like that, or do you find it well balanced, the system as is today?
Well, we had a very clear example of that during the COVID pandemic,
Yeah,
and where the companies that developed the vaccine, by the way, there was a vaccine developed in Brazil by Fiocruz, which is a scientific research health institute in Brazil, government owned, and they partnered with a Chinese company, and they developed one of the vaccines. But the other main vaccines, at least the one from Pfizer and from AstraZeneca, Oxford, they were made available, and I think that they were made available with a very generous offer and conditions, and that was while respecting all the patent protection. Of course, there were patent applications at the beginning. It was really novel, but they are granted today, and the vaccines have not. We never felt a shortage of vaccine, neither in Brazil nor in South America. Those are the countries that I am most familiar with. In Brazil, in general, for other types of pharmaceuticals, there are different. The issue is a little bit different. The government understands that fostering patent protection is important to an extent that there is a program. It's a wide program that involves the Ministry of Health and our own FDA, which is called Visa, and also the BPTO, which is a fast track for neglected and rare diseases, AIDS and cancer treatment. So any patent applications that are geared towards those four cases, AIDS, cancer, rare or neglected diseases, they enjoy a fast track in Brazil. So it is clear for the government that that awarding patents is part of the public policy regarding health. If needed, that was done just once, at least since our Constitution of 1988. But if needed, there can be a compulsory license. There are clear rules for compulsory license. They were changed a bit, specifically for the pandemic. But I think that they are very they are very balanced. They give the owner of the IP, of the patent in general, all the chances to defend themselves, and there's payment for that license as well. But anyway, that we only had one instance of compulsory license being decreed. That was for one of the pharmaceuticals in what we call the AIDS pharmaceutical cocktail, and very quickly the company, the owner of the patent, came to terms with the federal government. So it's much less. There are much less cases of patent compulsory licensing in Brazil than in the US, for example, which is a developed country where most of the pharmaceutical patent applications come from.
Yeah.
So yeah, in general, I would say there is a nice balance. This is a topic actually that can that there's an iceberg part to it, so to speak, because a lot of the changes to the patent legal system, for example, the declaration of unconstitutionality of we had a compensatory term of 10 years from grant of the patent. So our listeners who probably are not very familiar with patent systems, in general, you have 20 years from filing. So the time that the patent application is being examined during prosecution eats up, so to speak, the total time of the patent. And in Brazil, we still have that issue of not having enough examiners, and so a lot of patents, especially pharmaceutical patents, which are per se more complex, especially the biotech ones, they were granted like 12, 15 years, 18 years after filing. So that compensatory term was applied, and it was with time it was not viewed very well, especially because if there is a patent or even a patent application, but with good chances of maturing into a patent, the Brazilian government must buy the pharmaceutical directly from the owner or a licensee. And Brazil has a unified health system, which buys a lot of pharmaceuticals and medical devices and anything related to healthcare, and gives it for free for the population. So all along Brazil is a continental country. It's bigger than Europe. Of course, without Russia, without counting Russia, and so there's a lot of money and public spending involved. So there's that part. There are other discussions on that, but we would need a new podcast. I
Yeah,
believe. I'm afraid we would need a new and longer podcast just to
yeah,
tackle that issue. But in general, my response would be that there is a good balance. I would like very much to see the BPTO enhance that time that for examination. That would make things much easier.
yeah.
So if we could reach the levels of developed countries. By the way, Philip, I don't know if you have that information, but what is the average time for patent examination in Sweden?
Ooh, I don't have it on top of my mind right now. It can vary quite a lot, of course. But I mean, the Swedish IPO is, of course, also under pressure when it comes to examinations,
Yeah.
both regarding trademarks and patent and all other registered rights, of course. We've seen a increasing number of applications for intellectual property rights, of course, during the last couple of years. So the time for processing an application has, of course, become somewhat of a obstacle, but it's not a major issue at this point.
Yeah, I believe it's probably much better than Brazil. Brazil, the two focal points are biotech and telecom. And
Okay.
internet related in general inventions.
Yeah.
Um, but anyway, one thing that is quite important to highlight, especially for our audience, is that without patent protection, without IP protection, um, there's very limited incentive for innovation. So that's why WIPO and the UN mention innovation and the IP ecosystem as parts of their sustainability goals. There are a lot of critics of patent systems and IP in general, but it's going on for quite a while, for more than 1.5 centuries, and it's the system that is working. Maybe something will be invented regarding regulations in the future, but it's the system that has been working. And if there's no patent protection or patent protection, the patents are not really enforceable by the courts, then there is disincentive, and probably that country will only see that pharmaceutical that is protected. For example, pharmaceutical is just one example. Once there's a generic company able to make it, but the generic company lives off the inventions, the research and development of those pharmaceutical companies. So there's a cycle there, and yeah, this is not lost to Brazilian government policies, and not to the UN as well. I would like to we are focusing a lot on patents. I would like to just mention one other IP that I have seen that enhances a lot the lives of the owners in a collective way, which is very nice. Especially in Brazil, have very successful stories, which are the geographical indications, the GIs. And there are types of GIs, but I won't go into that. But the GI is a type of protection that certifies that a product or a service from a determined geographical space has a high quality. Not only a high quality, but special quality due to the geographic conditions or to the social and cultural conditions even. And in Brazil, we have more than 100 GIs granted specifically to local communities that have developed along the years products or services that are highly valuable. And with the GI, there's value, of course, added, but the certification, which is a national certification, it attracts more consumers. It attracts tourism as well. A lot of areas that were out of the tourist usual route, they have been included because people want to see that traditional production, etc. And that means an inflow of money, of income to those areas, and we have seen a lot of enhancements of those areas. So that is goes very much in the way of the fight against poverty. And well, I would like also to highlight briefly the innovation on food as a way to fight hunger. So a lot of innovations are aimed at enhancing production of food quality and quantity as well. And I believe we are in a place in history where we never had as much food available for the population. Of course, there's a long way to go, but certainly innovation and patented innovation is very important for that.
Is the GIs, is that related only to food and food stuff, or do you does that regime also cover products and services, or is it just or primarily food?
No, it covers other types of products.
Yeah.
Of course, the edibles and drinks are a very important part of it, but
Yeah.
there are other types of products and services as well
Okay.
that are covered by it.
Yeah.
Usually, they're the traditional products that sometimes they have useful purposes. Sometimes they are just decorative, but they're quite innovative
Yeah.
in the way that they are shaped or the materials, the production system, etc.
Yeah.
One thing that I would just point out, because our time is unfortunately coming to an end, the podcast, but I must also mention, even briefly, the plant varieties, which is a type of IP that protects specifically the varieties of plants, different plants, which also not exclusively, but also encompass food and also many of those enhancements that come from plant varieties and which are incentivized by the protection of the IP protection. They are geared towards productivity and also flavor and time that the food stuff can for example, fruits, the time that they can stay without rotting and other types of benefits.
Yeah. I was also thinking about when I started to look into this matter further. I was starting to think about the legislation itself and how IP rights are, or how the sustainability goals are reflected in the legislation itself. And I just want to mention I saw a couple of interesting, or I know about a couple of interesting acts that are on the way. You spoke earlier about how the system works and that it works well in Brazil, for example. And we actually have a brand new design package coming up in the EU. So we have a new regulation and a new directive. And I believe that earlier, because I mean, IP is a quite old area of expertise, and I believe that IP is older than when environmental and sustainability issues became a general policy goal. So
Yes.
earlier I haven't seen sustainability being reflected in the legislative acts, but now I believe that is about to change, or successfully change, at least. We have the new design package, of course, where for example, they mention spare parts as being crucial for the transition towards a more sustainable society. So they are actually introducing a mandatory provision now in the EU directive, which must be implemented in all the member states, stating that it's basically a limitation of the designer's right to must match parts. I don't know if you have the same in Brazil, but you cannot have protection for these must match elements that are a part of certain complex products, for example, a car. So that opens up. I mean, I don't think that the primary goal of that clause or that provision is specifically to contribute to the environment. I believe that there is also economic factors involved, of course, and competition factors to open up a aftermarket for spare products, of course. But I still believe that it's quite important that those factors are taken into consideration, and that those amendments are being implemented effectively, because I believe that is also very important in this work with meeting the requirements, that the legislator also focuses on creating this fair balance. Of course, the designer itself has a interest of protecting its product, of course, and the return of investment, of course. But it's also important that this is balanced well, and that you create some create possibilities for people to compete and create products themselves to which will help this transition work, of course.
Yes,
But
yes,
that's
I see your point. In Brazil, there was a discussion, a heated discussion on spare parts, design, protection, and aftermarket, but it alas came to nothing. And I haven't heard the competition authority kind of clean its hands and did not issue any merit decision.
yeah,
And yeah, the discussion is a bit dormant.
yeah,
There's no regulation as you have in the EU that is quite clear
yeah,
on the must match and
yeah.
protection of the spare parts and the aftermarket.
Yeah. But my opinion in relation to that is also that those kind of exemption, of course, they must be applied with some restriction, of course, because there are of course risks associated with that. And I actually read an article from I don't know if the people in Brazil is familiar with Volvo. Are you do you have
Yes, of
you
course.
have
Yeah,
Volvo?
yeah, we
Yeah.
have Volvo cars here.
Yeah, perfect. So I actually read a statement from Volvo when the EU started to discuss this repair clause, and I printed it out because it was quite interesting, and they said that the Commission's proposal would deprive an innovative industry of fair return of investment, threaten EU competitiveness and jobs because copies of automobile parts would be made, for instance, in Asia and South America, and undermine vehicle safety given that EU has no safety requirements in place for aftermarket parts. And although I do not agree completely with everything that Volvo said, I believe that there are some interesting points, of course, especially related to the return of investment. I believe that if you apply those kind of provisions too rigorous or too generous, of course, it will in some sense impede with the industry's will to create and innovate. So I believe that again it must be fairly balanced, of course.
Yes, yes, I agree with you. Those kinds of regulations, they attempt to strike a balance between interests,
Yeah,
and I believe they don't want to disincentivize designers and design owners from innovating. Yeah, so it seems that there's a legitimate concern from Volvo,
yeah,
perhaps one-sided, but that's their side. They are not judges; they are parties
yeah, of course.
to the issue. So yeah, and that's there's a very similar discussion here in Brazil, but without a clear regulation. I think that in general in Brazil, the IP rights in designs, they are considered in absolute terms,
Yeah,
affecting even the aftermarket. That's my reading of the situation. Philip, thank you very much. I believe we have a lot of other things to talk about this topic, but I need to we need to close
yeah.
to wrap up. Thank you very much once again.
Thank you.
I would just be remiss not to mention. I was planning to, but I would just very quickly mention that the BPTO has a green patent highway. So applicants of inventions that are beneficial to the environment, they can use that highway upon payment, of course, but have their patent applications examined faster. And that is also a part of the public policy towards environments, and very much goes in the way of the sustainability goals of UN. So thank you once again, Philip, for accepting the invitation to your point of view about Sweden and the EU was very interesting. I learned a lot today. I hope that our listeners as well. And thank you everyone who listened, and stay tuned for the next episodes of the DBPACast.